During the bicentennial celebration of the Constitution, Justice Thurgood Marshall said, "While the Union survived the Civil War, the Constitution did not. In its place arose a new, more promising basis for justice and equality, the 14th Amendment." From the ashes of the Civil War, the 14th Amendment, authored by Ohio Congressman John Bingham, was ratified in response to the many problems apparent during Reconstruction. The basic purpose of the 14th Amendment was to establish a national definition of citizenship in order to provide classification for the newly freed slaves.
Additionally, the 14th Amendment protects the privileges and immunities of all citizens, including due process and equal protection of law to all persons, by enhancing the natural rights philosophy outlined in the Declaration of Independence, though through ensuring life, liberty, and the pursuit of happiness. The amendment also applies restrictions against Southern disenfranchisement, punishes Confederate officials, and negated the debt of slave owners while giving Congress the power to enforce the amendment by appropriate legislation.
The importance of putting federal power ahead of states' rights was founded in the failure of the Articles of Confederation and the necessity of the Philadelphia Convention. The 14th Amendment in part answered some of the questions left unresolved at the Philadelphia Convention, but more importantly, it set off a chain reaction of promising a basis for justice and equality, as stated by Justice Marshall. Questions about citizenship, voting, representation, and a significant check against state power were left unresolved to appease many delegates.
In Federalist 54, James Madison affirmed that slaves are not considered as property. Slaves are considered as property, not as persons, and resolved to count them as 3/5 of a person. The 14th Amendment not only gave the freed slaves just solely citizenship, but also counted them as a whole person for purposes of the census. The Privileges or Immunities Clause of the 14th Amendment was designed to protect the applications of the Bill of Rights towards states, overturning the 1833 Barron v. Baltimore decision. However, the 1873 slaughterhouse cases effectively eliminated this clause, postponing incorporation until 1925. In Gitlow v. New York, the Supreme Court ruled that the First Amendment limited all states according to the Due Process Clause of the 14th Amendment, reversing the Barron decision and beginning the incorporation of the Bill of Rights to limit the states.
The principles of limited government are reflected in the Due Process Clause, which limits states from passing legislation that violates both procedural and substantive due process. Procedural due process requires that states act in a certain way before they can take a person's life, liberty, or property. It is this idea that allowed for the doctrine of incorporation to prevail, as seen as the 1932 case Powell v. Alabama, which incorporated the right to fair trial, prohibiting states from arbitrarily denying any person their due process. However, incorporation is not absolute.
In the 1937 case, Palco v. Connecticut, the Supreme Court stated that the Double Jeopardy Clause of the Fifth Amendment did not apply to the states, because states may also have a compelling state interest to uphold their own due process in criminal or statutory cases. Substantive due process protects certain fundamental rights, such as privacy or marriage, that cannot be infringed upon by the government without a compelling state interest.
The Equal Protection Clause upholds the ideals of a limited government by prohibiting states from denying all persons equal protection of the law. States also often establish laws that create classifications, such as Nevada Revised Statute 433, which provides definitions for mental health. In the 2001 case, PGA Tour versus Martin, the court used a rational basis to rule in favor of Casey Martin and allow him to use a golf cart because of his circulatory disability.
Cases of race would fall under strict scrutiny, and gender would fall under intermediate scrutiny. As the issue of same-sex marriage makes its way to the Supreme Court, the question of which classification the court will use will become important to legal scholars as the clause continues to progress. Equal protection under the law is one of the most important safeties to fundamental and inalienable rights such as life, liberty, and the pursuit of happiness. Thank you.
What is the idea of selective incorporation?
The idea of selective incorporation is that the Supreme Court will use the Due Process Clause of the 14th Amendment to incorporate certain rights found in the Bill of Rights on a case-by-case basis. So they're not going to come out and say that every part of the Bill of Rights applies to the states, but they're going to do it as the cases come forward.
What parts of the Constitution or the Bill of Rights haven't been incorporated?
the double jeopardy clause of the Fifth Amendment hasn't been incorporated
Yes, it has.
as seen.
Yes, it has. That's something you guys need to know. What parts haven't been incorporated yet? No question?
Is there sometimes a conflict between procedural due process and the common good?
Procedural due process can sometimes conflict with common good. For example, in terms of safety issues, procedural due process can be occasionally withheld from certain people in order to try to maintain safety throughout or in a certain region. For example, in Ferguson, some people were being held without necessarily being charged or explicitly stated why they're being held, which was only occurring because they were in a possible dangerous situation or could help contribute to a possible dangerous situation for others.
I disagree with Max. I think that, not saying I think, procedural due process promotes the common good because due process is a promotion of common good and the protection of all of our rights under the law.
An example?
Well, for example, if a policeman is against, for say I'm speaking out some hate speech, which I would never do, but a policeman is against something I'm saying, or even if I'm not doing hate speech, if I'm just expressing my First Amendment and he believes it's hate speech, I could be arrested. I don't really know where I was going with that, but it can have a sort of bias if someone isn't following procedural due process that doesn't support the common good. If that makes any sense.
Does the incorporation of the 14th Amendment promote the common good or protect individual rights, or both?
It's a combination of both. For example, the incorporation of the First Amendment to states permits really an active democracy. As Thomas Jefferson said, dissent is the purest form of patriotism. If through the First Amendment people are able to dissent freely. So the incorporation of the Bill of Rights to states is really promoting those individual rights of, protecting yourself through the Second Amendment, or promoting what you believe in, or having a religion with the First Amendment, but it also goes for the common good, as the common good is supported by those things within the Bill of Rights.
Right, but specifically with the 14th Amendment, how did the 14th Amendment help the common good or individual rights?
Through incorporation.
Yeah. Oh, okay. Sorry.
That's my answer.
Okay.
That's your answer.
Sorry.
One of the most controversial aspects of the 14th Amendment is the enforcement provision, through Congress's enforcement provision. How have they enforced the 14th Amendment, and what limits have been placed upon that very same clause?
As far as enforcement goes, after the schools were desegregated in the South, they sent forces down to ensure that
I want to know how Congress enforces the 14th Amendment. This is by appropriate legislation. I want Congress in this.
Well, in a broader, more metaphorical sense, you can say that Congress is really supporting ideals within the 14th Amendment by any legislation that supports equality. Whether it is supporting equal pay, whether it's trying to apply federal legislation to support, family planning, things like that. Any supportion of equality is seen within the 14th Amendment and then, therefore, through Congress.
Can you repeat the question one more time?
How has Congress used its appropriate legislation to enforce the 14th Amendment?
Congress has used legislation to help enforce the 14th Amendment through, for example, voting acts or equal rights acts, which help to enforce just equal protection of people under the Constitution.
Okay. My next question, I'm going to follow up on that. My next question is going to be, how have procedural and substantive how can a law both infringe on procedural and substantive due process at the same time? So I don't want an answer to it, just something to think about in terms of how can they both be checked, or not checked, but how can they both be infringed at the same time? My last question, how has Congress enforced the 14th Amendment? Civil Rights Act of 1964 is your go-to. It's the easiest one of all time, right? It desegregates public spheres. Congress created the Freedom of Religion, Religious Restoration Act, which is one of your Supreme Court cases that you had to do for federalism. What case was in question for that?
Which case was it?
Which case, for your federalism cases, questioned the constitutionality of the Freedom of Religion Restoration Act? City of Bourne versus Flores.
Oh, I remember that.
And that case limited the enforcement provision in the 14th Amendment. So it is a case you need to know and be able to use, and we'll talk about it more next week so you understand it, but it is definitely a huge question in that. Kazenbach versus Morgan also lays out how the Supreme Court has laid out rules for the enforcement provision of the 14th Amendment. Kazenbach versus Morgan. Senior book. Okay, Tommy, what do you got?
So for the most part, I think you guys did a good job. I would have liked you guys to cite more Supreme Court cases, just because.
Across or in testimony?
In both actually. I feel like you guys could have, you guys had, I think, one in the testimony. But I felt like there were spots where you could incorporate that a little more, specifically with the last question. And also, I kind of felt like on cross-checks, for the most part, just kind of one and done when you guys were answering the questions, instead of actually kind of having a conversation about it and disagreeing with each other. So I feel like if you guys really kind of talk more on the same question, it would really help you guys in cross-checks. But overall, I liked your answers on almost all of the questions, and I thought you guys did a pretty good job.
Your testimony was a little bit wordy. It could have used more examples. That's really what the judges want to hear. It's not you re-explaining what really specific terms are. They want to hear how you can understand them and apply them. So, and then again, in cross-ex, you guys really talked about it, but you didn't necessarily give specific examples. So if you could just be really specific and always have an example, like a really pertinent example. And again, like Tommy said, it seemed really one-sided. Like you should address both sides of the question. So if it's if you can address the pros and the cons, you always need to do both sides. So make sure that you guys work together as a unit so you know who's going to talk about which side, so that you can have the conversation with the judges.
I know we sat down and really reworked this, so I'm going to say the testimony, I can see what they're saying in terms of the examples. You didn't emphasize the examples because you guys don't know it well enough. Because I know the examples are in there because we sat down and really went through this. We've got to emphasize it better, which comes with the practice of knowing our parts. I think it's either an Annie or Max's spot where you said it appeased the delegates.
That's Max's.
So beyond appeasing the delegates, who else?
No, wait, that's mine.
Who else were trying to appease? Who else were really trying to appease?
People who are voting
Right,
to ratify.
to ratify. So I think we
Yeah,
can make that it was more to get it ratified than anything. And then James, will you read your 3/5 clause section?
James Madison affirmed that slaves are considered as property, not as persons, and resolved to count them as 3/5 of a person. 14th Amendment not only gave the freed slaves just Soleil citizenship, but also counted them as a whole person for purposes of the census.
We have person a lot in there. This is person. So we just rework the person part.
Earlier time was 4:08.
That's not bad. I think practice, because you stumbled a little bit.
Yeah,
Do
true.
you guys all need to hold your papers the same? So don't have some people looking down and then some people holding them up, just all hold them up. So you're speaking to the judges and you can make eye contact easier once you get to know your parts.
How can procedural due process and common good come into conflict? Other than your hypothetical, how can it really come into conflict?
Crisis situations.
Like what?
Time of war,
So with
seizure, like you
internment
could
of
do the
Japanese,
inter- yeah, I was just
I
about to say
totally, okay, so there's one. They had the writ of habeas corpus taken away from them, right? Good, so we're taking common. One of the easy ones is, if I know Tommy is a criminal, I know it. I know he's selling drugs out of his house. I know it.
that. That's
Okay? I, as a police officer, still can't go into his house and search. Even though he is corrupting the common good of the neighborhood. I gotta get a warrant. I gotta make sure that I have enough probable cause to have it both, right? So that's common good and procedural due process coming into conflict. I should be able to go and get him. He's a bad guy.
Have you guys seen Breaking Bad? The episode where they're like in the like the RV thing, and like the guy comes and tries to look around the RV. It like kind of